A wife passed away in a hospital due to unnatural intercourse. According to doctors, she suffered from peritonitis and rectal perforation. In her dying declaration, the woman accused her husband of forceful sexual intercourse, which led to the medical complications. The statement was recorded before an executive magistrate. Following this, a trial court convicted the husband and sentenced him to 10 years in prison. But now, the Chhattisgarh High Court has reversed the judgment. The High Court observed that a husband cannot be charged with rape or unnatural sex for engaging in sexual relationships with his wife, regardless of her consent, as long as she is above 15 years of age. Hello and welcome. This is Akanksha and you're watching HW News English. On Monday, the Chhattisgarh High Court acquitted a convicted man for rape and unnatural sexual offence. The man was arrested in 2017 and later convicted by a trial court in Bastar district. The judgment was ruled by a single bench of Justice Narendra Kumar Vyas. The case revolves around a notion of consent in marital intercourse. The bench ruled that if the age of the wife is not below 15 years, then any sexual intercourse or sexual act by the husband cannot be termed as rape. In such circumstances, the absence of the wife's consent loses its significance. The Supreme Court ruling that raised the age of marital rape from 15 years to 18. In October 2017, a two-judge bench read down the exception 2 of Section 375 IPC and raised the age of consent to 18 from 15 for the purpose of exception. The reforms were made to prevent and address the violation of girls' rights due to the child marriage. Meanwhile, the defense argued that there was no legally admissible evidence against the accused and the conviction was based solely on the victim's statement. It also questioned the reliability of the dying declaration. Following this, the court cited Exception 2 under Section 375 of the IPC, which exempts a husband from prosecution for raping his wife. The court also said that the trial court has not recorded any finding on how the offence under Section 304 of IPC is attracted to the present facts of the case and provided by the prosecution. Still, it has convicted the appellant under Section 304 of the IPC, which is nothing but perversity and patent illegality that deserves to be interfered by this court. Now, based on the findings, the Chhattisgarh High Court acquitted the man of all the charges and ordered his immediate release from the prison. Under the current Indian law, marital rape is not recognized as an offence. A husband's sexual acts with his wife, no matter how forceful, do not amount to rape or unnatural sex. Now, these laws are mentioned under Sections 376 and 377, that is rape and unnatural sex of the Indian Penal Code. Similarly, in May 2024, Madhya Pradesh High Court ruled that unnatural sex with wife is not rape and that a wife's consent is irrelevant in such matters. The court revoked an FIR filed against husband by his wife accusing him of having unnatural sex. This ruling was again passed by a single judge bench, Justice G.S. Ahluwalia. In his judgment, he noted that sexual acts that include penetration of the mouth, urethra, or anus are considered to be unnatural under IPC. But if it is performed by the husband on his wife, provided that she is over 15 years old, her consent does not matter legally. Well, now the High Court's judgment leaves unnatural sex and rape out of the ambit of punishment. And also, there is no law in India that will punish a man for raping his wife if she is above 15 years. It's 2025, but India is still sadly one of those countries in the world today that explicitly decriminalizes marital rape. And India has been a signatory to the Universal Declaration of Human Rights since 1948. However, this decision by the High Court have caused a lot of commotion and uproar on the social media. Lastly, let's end this with a question. Is the wife the property of the husband? Our judicial system tends to pass such verdicts, which makes me believe that. So, if I marry someone, that person owns me. Will I have no say in the relationship? Well, the answer is a big fat no. a wife is not considered as the property of her husband. According to modern legal and societal views, a wife is an equal partner and individual in a marriage. She has her own independent rights, meaning that she cannot be treated as someone's property. By the way, it's not me who is saying this, but the laws explicitly state that a wife is not the husband's property. Also, no human being is legally owned by anybody, anywhere in the world. Did you know that our Constitution has a legal principle, the right to choose, which is interpreted in Article 21. This right includes the freedom to make choices and the right to privacy. Now let's also take a look at the definition of rape. Rape is a heinous act of sexual intercourse committed against any natural person forcefully without their consent. The Section 375 of the Indian Penal Code defines rape as an act committed by a man against the will and without the consent of a woman. Without the consent, let's make a note of that. So if that's the case, then why does the consent of the wife to have sex in the marriage does not matter? If she says no, how can she be forced? Isn't the consent of an individual their legal right? How can the court take away this right? While unwilling sexual contact between a husband and a wife is recognized as a criminal offence in almost every country of the world, India is one of the 36 countries that still have not criminalized marital rape. Well, do let us know what are your thoughts on this verdict by the Chhattisgarh High Court. Until then, keep watching HW News English and also download our app HW News Shorts for the latest news and updates.
Stay ahead with our cutting-edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.